Hello, everybody. My name is Larry Kobak, and I will be your presenter today. I'd like to thank you all for joining us for this special event. Today's webinar is being co-sponsored by Frier Levitt and Physicians Reciprocal Insurers, and will focus on surviving a state administrative investigation. Before we get started, I just want to note that all lines have been muted. Also, I want to remind you about the question tab on the right side of your screen. Go ahead and type in your questions throughout the webinar today. I'll either wait till the end of the presentation to answer them, or some of them I might actually work right into the presentation. We'll try to get to all of them on the live webinar, and if not, we'll get you on emails afterwards. Okay? Everybody ready? Let's go. Now, what do we mean by surviving a state administrative investigation? Well, let's see. First of all, with everybody who is in New York, who is a physician, you have to have a license. You have to have a license to practice medicine. And there are certain requirements to get a license in New York, believe it or not. You have to be at least 21 years old. So unlike Doogie Howser, those of you are old enough to remember that TV show, you do have to be 21. I myself, when I became a doctor of podiatric medicine, I was 22, so I just made it. But you still have to be 21 years of age to be a licensed physician, an MD or a DO in the state of New York. You have to be of good moral character, whatever that means in today's day and age. You have to be a United States citizen or lawfully admitted alien for a permanent residence in the United States. You have to pass a licensing examination in New York to become a licensed physician. Now, please remember, to have a license in New York State, it's a privilege. It is not a right. It is a privilege. And that privilege could be taken away from you. And it can be taken away from you or limited by the Office of Professional Medical Conduct for MDs, DOs, and physician assistants in New York State. And that's really what we're going to be zooming in on today when we talk about the Office of Professional Medical Conduct, which is a part of the Department of Health, which is in turn a part of the government of New York State. And it's governed by New York State Education Law 6524 and Public Health Law 230. All right. Now, you have to pay a registration fee to become a physician, licensed a physician in New York State, as well as getting a degree, an MD or a DO. And you have to pass that examination and to become a physician. You also have to take courses in infection control. And in these days, if you're writing for opioids, you have to take 4 hours worth of opioid training. You have to keep your New York State physician's profile up to date. And that means that within 30 days, when you're going to renew your license, if there are any changes, you have to make sure it's up to date and change it. If anything changes of an important nature prior to you re-registering, you have to go into the website, or you could do it on phone or via fax, and you have to update your New York State physician's profile. Many of the doctors on this call may not even know that there is such a thing as a New York State physician's profile. But simply go into your web browser and type in New York State physician's profile, and you will see it come up. You'll type your name in. Some of you may see that the last time it was updated was 2004 or so. You have to update that profile, because an outdated or an inaccurate New York State physician's profile is itself actionable by the Office of Professional Medical Conduct. It's something that's so easily corrected, you just don't want to go there. There's no reason to. Now, what things are reportable in New York State to get you in trouble to begin with? Well, first of all, if there's any change to your hospital privileges that impact your privileges more than 30 days, and that it bears with your ability to practice medicine, that's reportable. So such things as substance abuse, that's reportable. If there is some kind of limitation of your hospital privileges for more than 30 days, that's reportable. If you are kicked out of a residency program, that's reportable. All right. Now, you have an obligation as a physician in New York to actually report your colleagues if you have a reasonable basis to think that they're guilty of professional misconduct. I like to call that the KGB rule from the old Russian secret organization, from actually the Soviet Union, I should say, in the sense that we have to report on our colleagues. But keep in mind, it says reasonable. You have to have a reasonable suspicion. So that if you see a colleague walking out of the bathroom, reinserting a needle or a needle in their pocket, don't assume that they're shooting drugs. Perhaps they're diabetic and they just were shooting some insulin. So please don't, before you go ruining someone's career, make sure you know what you're reporting. Just don't do things out of spite. It's not right to do that. It's also very unprofessional in and of itself. And it's also the start of many lifelong arguments between various professionals that take on a life of their own, and it does you absolutely no good. Now, anytime an action is reportable to the Office of Professional Medical Conduct, it's also reportable to the National Practitioner Data Bank. That's federal. Remember when you were little and your teachers would tell you if you misbehaved, it's going on your permanent report card? Well, the National Practitioner Data Bank is your permanent report card. On that are any things that are reported, such as your hospital privileges for more than 30 days, medical malpractice, professional misconduct, that gets reported. And the reason why this is important, is because when you have these problems, they're very often the gift that keeps on giving. So it's not just the Office of Professional Medical Conduct, but the various insurance carriers that you may be in network with, they receive these reports. The various hospitals you may be on staff with receive these reports. And what happens is they could kick you off the panels. And in certain instances with your job, you could get fired. You could get terminated. If you take a look at the clauses in your employment contract, it says that if your office privilege, if your hospital privileges in any way are cut short or made less, they could terminate you. If there's any kind of medical discipline, they could terminate you in your job. So this is often the gift that keeps on giving, and I don't mean that in a nice way. What are the source of complaints to the New York State Department of Health? The source of complaints, generally they're anonymous. You're not going to find out who made the complaint unless it actually goes to a hearing, and that's if only the person who makes the complaint is a witness or has provided some kind of document that they have to make public as an exhibit. So, but very often you can ascertain who made the complaint just by the nature of what they're investigating. The settlements of any and the charges themselves, if they actually bring them against you, formal charges, they're made public in a searchable database that's online. So again, this is the gift that keeps on giving. Often, the source of complaints are disgruntled former employees. Those are words you really don't want to have in the same sentence. If you have to fire an employee or terminate an employee, let them go. Try to do it in an agreeable way if that's possible, with a smile, maybe some notice, maybe some severance pay. But what you don't want to have them disgruntled if you could avoid it. Disgruntled former employees can make a lot of trouble for you because they think they know a lot more about the way you practice than you do. And very often they're the source of False Claims Acts reports, which could be criminal. They're the source of reports at OPMC, which are free and easy to make and make them right online. It doesn't cost the reporter, the person making the report, any money whatsoever. That's a big source. Disgruntled patients, especially patients that you don't get back to in a timely fashion or that you may have an attitude with, they're a big source of complaints. Another source of complaints are insurance companies. If you generally give insurance companies a hard time, or if your pattern of practice is outside of the norm, that's a source of complaint. Often with pharmacy sweeps, with a pharmacy sweep of a governmental investigation, they see, just by coincidence or ancillary nature, they see that you, the doctor, are way outside the norm for your amount of prescriptions for various types of medications, often opioids, but not always, benzodiazepams too. Those are the substances they're looking for, the narcotics mostly. And these are things you want to watch out. If you're practicing outside the norm, it can create a report to the OPMC, and the investigation is off and running. A lot of reports from insurance companies in the no-fault arena. The insurance companies use the OPMC basically to try to take the doctor out of the game, and often it's very effective. Malpractice. If you settle a case or that you go to a jury and there's a large verdict, and large is a term I can't define other than to say it's somewhere in the mid to high six figures and greater. We don't know what the actual number is, but that will trigger an OPMC investigation. Often, you don't even know you're getting investigated at first, and often they close these investigations, and you never know you were investigated. Many other times, they will send you a record on the OPMC, Department of Health stationery, asking for a copy of the records. And it's closed without, once the records are reviewed, it's closed at that stage. Actually, a very large percentage of the investigations are closed at that stage. Many of the investigations will go further, and they'll get to the stage where they want to interview you. Certainly at the stage where they ask for your records, you should be retaining a healthcare attorney. Now, this is not a commercial, because there are many fine healthcare attorneys in the state of New York. I'm not here to tell you that I'm unique in that way. But the point is, you should be contacting a healthcare attorney, someone experienced in the OPMC field, because OPMC is administrative law, and it has many wrinkles that are quite different than in a real court of law. For example, hearsay is allowed at OPMC hearings, and they can ask you all sorts of questions that they can never ask you in a real court of law. They could get witnesses to say and do things they never could in a real court of law. Frankly, the rules of evidence are discarded. But that works two ways. They're discarded for the state, and they're also discarded for you. So if your attorney knows what he or she is doing, that could very often work for you. Let's come back to what could get you in trouble. One of the reasons why the state would try to discipline you in the first place. Well, there's an old Paul Simon song called "There Are 50 Ways to Leave Your Lover," and there are approximately 48 ways to be disciplined or lose your license. And we're not going to have the time nor the scope to go into all 48 today. But the obvious ones are abuse of drugs, inappropriate relationships with patients, including sexual relations with an active patient, big no-no. Making it easier or employing someone that is not licensed and they are practicing medicine in some way. So they're doing something that requires a license to practice. And in effect, they're practicing under your license. That's not legal. It's not allowed. In New York State, the corporate practice of medicine is not allowed. Such that a company, not a professional corporation or a PLLC or a PC, but lay people, other than in a hospital or a nursing home, lay people cannot own your practice. They can help to manage your practice, but they cannot own your practice. They cannot make the medical decisions. You can't delegate that. Only you could do that. All right? So if you're allowing someone to run your practice that's not a licensed physician or a physician's assistant to help treat patients or a nurse practitioner, then you could be guilty of what's called the corporate practice of medicine. We particularly see this in the no-fault arena. And the OPMC, as well as the government, state and federal, have used this very effectively to go after physicians, sometimes criminally. By the way, that's another source of referral. If you're convicted of a misdemeanor or a felony, that will automatically be referred to the state Office of Professional Medical Conduct, and you will go from there. You can't, and when that occurs, you can't deny what you've pled guilty to or what you've been convicted of. You can't say, I really didn't do it, and here's the reason why. It's too late for that. You've already been found guilty beyond a reasonable doubt, or you've already pled guilty, so there's no reasonable doubt. You can't say you really didn't mean it. That will not work. A violation, however, is not reported. And by a violation, I mean like a traffic ticket, a speeding ticket. Certain types of intoxication are violations. Certain types of DUIs are criminal in nature, and they are actionable by the Office of Professional Medical Conduct. So you have to be careful for that. Practicing beyond your authorized scope of medicine is reportable. All right. So if you're an internist, you legally could perform brain surgery. But let's say you were in a hospital and your privileges were such that you went beyond your privileges. That's reportable. You can't practice with incompetence on more than one occasion, or gross negligence even one time. So you have to stick to the area of medicine that you're familiar with. You can't practice while you're impaired by any substance. Or for that matter, you can't practice while you're impaired, period. Period. So if, let's say you didn't take any illicit drugs or legal drugs or alcohol, but you're still impaired, you're so tired, you have a medical condition, you forgot to take your medication, you shouldn't be practicing. Someone could get hurt and it's not allowed, and that's reportable. You can't, now look, in New York State, a physician could refuse to provide care to any person who's not currently a patient for no reason. But there are some reasons you can't refuse. So you could refuse to treat someone because you don't want to treat someone. There's no reason. But you can't say, I refuse to treat you because you're a particular nationality, religion, or race. That you can't do. You can't blanketly refuse to treat people that are HIV positive. But if for some reason your training is inadequate in that area, if there's a legitimate reason why you can't, then you don't have to take a patient as a patient that's HIV positive. All right, but if you just blanketly say, I'm not going to take gay people as patients, that's actionable. You cannot do that. It seems pretty obvious. You can't practice while your license is suspended. But we've had more than one client over the years that did just that. They thought they could get away with it. It was a week before their suspension was up from a prior OPMC action, and the state sent what we call a shopper into the person's office, and the office was open, and the doctor was taking appointments, and the doctor was busted. Not a good idea to do. Not a good idea to do at all. You can't exercise undue influence over a patient, sort of to be what they used to call their Svengali. Basically, you can't control the patient and try to, especially for financial gain, you can't exploit a patient. You can't practice while you're morally unfit. And that's a very nebulous term, and the state usually uses that as a cover to that you can't have inappropriate relations with patients, including dating them. It's not appropriate to date a current or active patient. The way to do that is if you have to, and I don't suggest it, but if you feel you have to date someone that is currently a patient, don't date them and refer them to some other physician sometime afterwards. Then if you have to, date them. But they can't be an active patient at the time. Revealing personal information about a patient without the patient's consent, that's actionable. That's a violation of privacy, both in New York State and federally. In some ways, the New York State privacy provisions are even more stringent than HIPAA, the federal provisions. You can't do that. And I've had occasion where doctors, nurses, and office managers were texting and were on Facebook and didn't realize certain things. You can't do that. And you have to be extremely careful if you're in a relatively small town, because often people that are also your friends are also patients. So you have to be very, very careful, and your employees, because you are in charge of your employees. Your employees have to be trained to respect that too, because if they don't, you could wind up at the OPMC because of their actions. All right? That's important. You can't abandon a patient's care of a patient when they're in the middle of a course of treatment. If you want to give a patient up because they're not following medical advice, you're not connecting, there's just a personality conflict, there's something off, You could give them an actual letter. I would send it certified return receipt, give them 30 days notice that you'll continue to treat them during these 30 days for whatever you're actively treating them for, and then try to refer them to another physician or to an emergency room, or just give them the state medical society state of New York's phone number for a referral if you have to. But you can't just abandon a patient. That is actionable. Actionable meaning against your license. Okay. You can't fail to supervise appropriately people that work for you. And we just got into that by medical assistants, LPNs, RNs, PAs, and Ps. You have to supervise these people that are working for you. All right? If they are working for you, it's your responsibility. Now, what are some of the penalties that the state could give? Oh, let's see. We have a question. Why don't we get to that? And it's, if insurance is terminated without any explanation, should that be reported? Or will it be reported? And the question is, if you are, let's say, on the United Healthcare panel of participating providers, and they terminate it as opposed to not renew your contract, and if they terminate it for a reason, that is reportable. If there's a mutual, sometimes these contracts have, if they give you 60 days notice or 30 days notice for no reason, they can terminate it. That's not reportable. But if it's reportable, it is reportable if it's terminated for some kind of a reason that involves your medical care. All right? A failure to renew a contract with an insurance company, that's not reportable. A terminated contract usually is. And if it's reported, you will probably hear somewhere down the line from the Office of Professional Medical Conduct, because they're going to want to investigate why you were terminated. That's also sent to the National Practitioner Data Bank, and in turn, you may hear from other insurance companies looking to terminate you. All right. Now, before we get to the penalties, let's get to the process a little bit. OPMC has asked for records on, let's say, 2 different patients. You provide the records. You've retained an attorney. The attorney and you have reviewed the records. Sometimes the attorney has already retained even an appropriate expert to try to find out what the possible weaknesses of your records are, what it shows. Is there a pattern between the patients requested? Were all the, let's say there were several records requested, all the patients had prescriptions for narcotics, or all of the patients had a particular type of treatment, or all the patients had some kind of chart deficiency. These are the things that your healthcare attorney should be looking for. All along, your healthcare attorney should be appropriately preparing you for an interview, which will probably be forthcoming. And then you get that letter, and your attorney gets the letter too, that they want to interview you. Do you go for an interview? Is it mandatory? Must you go for the interview? And the answer is, it is totally voluntary. Usually, however, I advise my clients to go for the interview, and you go with your attorney. Your attorney will prepare you for the interview. Your attorney will attempt to find out as much as possible as far as the subject matter of the interview prior to the interview. So it helps when your attorney has a good relationship with the various investigators at the Office of Professional Medical Conduct to try to find out and tease out a little bit more what their issues seem to be. So obviously, the more you know what the issues are, the better you can prepare for your answers to these issues. That's extremely important. This is not jazz. We are not making it up as we go along. While we don't want our clients, you, the physicians, to be scripted or sound scripted, we don't want you to be surprised when you walk into the room for an interview. We want you to be the smartest person in the room on those particular issues, on those particular patients, because only you, of everyone sitting in that room, treated those patients. The people in the room will be the attorney, you, the investigator from the Office of Professional Medical Conduct, often who's a registered nurse, but not always. Sometimes they're retired policemen or investigators or detectives. And there'll also be a physician of an appropriate specialty. Now, they say appropriate specialty, but it's not always the exact specialty. Often it is. Most of the physicians are clinically oriented, and they're not out to get you. There are a couple of ivory tower type physicians, but most of them, frankly, are clinical physicians that actually have treated patients, and they understand where you're coming from when you're explaining why and how you treated these patients. However, preparation is important as far as how to react to certain things that the physicians may say or ask. And again, preparation is crucial, because what's going to happen is generally these interviews last anywhere from an hour or so to in much larger cases that they could go all day, sometimes even more than one day. Most cases, generally, it's an afternoon or a morning, and you could tell very much how they went by the time you're finished, as far as the type of questions asked, the attitude of the physician that's asking most of the medical questions. Generally, the physician, not the medical investigator, ask most of the detailed questions. And you have to sound like you know what you're talking about. You don't want to give answers in the conditional meaning. Usually, I could have, I should have, I would have. That just opens the door for further investigation. So whenever possible, if you are the master of what's going on, because you know how you treated your patients, you could speak in terms of this is what I did, this is why I did it, this is how I did it. That's very important. Now, your records, as we all know, don't always give the whole story. So you have to connect the dots and fill in the blanks. While talking about medical records is a different lecture, let me just say that the single best exhibit that you could have to help yourself are your medical records. The more your medical records connect the dots. For example, if there's an issue of inappropriate touching with a patient, was there a chaperone in the room at the time? Do your records reflect that there was a chaperone in the room at the time? Well, usually when that occurs, it's a very short interview. Do your records connect the dots? Here's an example of that. In the intake, we have it that the patient is allergic to penicillin. 2 years down the road, you take an incision and drainage of an abscess, not an unusual procedure. You get back the culture and sensitivity report several days later. It says that it's most sensitive to a cephalosporin, let's say Keflex. But you have been trained that that you were taught that there's a cross reaction between people allergic to penicillin and cephalosporins of about 25-30% of the time. Not everyone agrees with that, but that's how I was taught when I was in school. So you give instead a prescription for Levaquin, which was next best in the culture and sensitivity. But you don't say why. Well, at the interview, you could explain why you didn't give the most sensitive antibiotic. But it would be better, the gold standard, if your record explained why and your record connected the dots that you gave Levaquin as opposed to Keflex because you were worried about possible cross-reactivity with the penicillin allergy. The more dots you connect, the easier you make it for the investigators to understand why you did what you did when you did it, the better off you will be. Let me say that again. The more dots that you connect, or that your records actually connect, you will make it easier for the investigators to go away, in plain English, to find that there's no reason to go forward in this investigation. And let me just get to that right now as far as penalties. If after the investigation, after the interview, you within 30 days, you get a letter of what's called a report of interview. And it's not word for word, it's not recorded. It talks about what substantially occurred during the interview. And you and your attorney will go over it with a fine-tooth comb. If there are really important mistakes, you want to correct it. in what we call a post-interview submission. Really, it's a fancy letter. You may want to emphasize certain points you feel aren't emphasized enough in this report of interview. You may want to refute certain points that you think they didn't get correct. They didn't get it correctly during the interview. You may want to actually use a certain medical literature to make your points in this post-interview submission. This is your opportunity, if it's appropriately done, to do that. By the way, are there any times where I would not produce my client for an interview? There are. If I feel the interview would just make an awful witness, such as the interview could just not be, the person being interviewed can't be prepped properly. They just can't keep their mouth closed. They just can't focus on answering the questions. Or in a no-fault situation, I really don't want them to say something that could get them in criminal trouble if they answer the questions truthfully. So in a situation like that, I might and sometimes do opt out of the interview. Totally legal, totally allowed, but most of the time we don't want the state to make the inference of just using the information that they've gotten that had nothing to do with you. So we do provide and produce our clients for the interviews, the vast majority of the time. So you've gotten the letter back from the state, and you've reviewed it, and you've submitted your submission. The vast majority of the times, you'll get a letter back in another month or several months, or sometimes even a year, believe it or not, afterwards, saying that they don't have enough information or evidence to go forward, and they're going to close the investigation for now. It's not the type of letter you really want to put in your waiting room and frame it, because it really does. It's not really what you want. It doesn't say we've investigated you and found you to be fine. They never say that, but they do say that for now they're closing the interview. That's about as good as you're going to get. Sometimes you may get what's called an administrative warning, where you actually come down to one of the offices of where the OPMC meets, such as in Manhattan, in Long Island, and Central Islip. You also have offices in Buffalo, Rochester, Syracuse, and Albany of the OPMC. And you would go to one of those places and get an administrative warning, where one of the physicians that are higher up in the Office of Professional Medical Conduct actually reads you a warning that what you did didn't rise to the level of discipline, but whatever it was, don't do that anymore. And you sit there and you listen and you shake your head nicely. And I would listen carefully if I were you, because what's going to happen is if it occurs again, then they're going to look to discipline you. All right, so that's an administrative warning. Sometimes you can get what's called the letter warning, where in the letter where they close the investigation, they tell you you have some minor deficiencies. Please don't do that anymore. And I would listen very carefully to that. But in effect, the investigation is closed and you've won because there's no discipline against you. Administrative warnings and letter warnings are not reportable to the National Practitioner Data Bank. They are not reportable on the OPMC website. You don't have to tell your hospital about it or anybody else about it. If you're ever asked in an application, have you ever been disciplined by an administrative body, state or federal? As long as you haven't been disciplined by some other body, the answer is no. So that's a win in administrative warning. All right. Anything more than that, though, is actually discipline. And you have what's called a censure and reprimand, which is public, and then it goes all the way up the line to an actual license termination. You have various types of things like probation, suspension. Sometimes part of your suspension is stayed, which means as long as you follow all the rules and keep your nose clean, that you could actually go in and practice. So if you were disciplined, and I'll get to how that the rest of the process in a minute, where it actually said you have 2 years suspension, the first year of which is the second year of which is stayed. For 1 year you couldn't practice. For the second year you could practice, but you better follow all the rules of the road, or they will unstay, to invent the word, the stay, and you will then not be able to practice for the second year. What happens after you get the report of interview back? Well, you can either get that letter closing the investigation, or you might get a letter that says something else. That one of the state prosecutors will be in touch. That they're going forward with bringing charges against you. Your attorney would call the prosecutor to find out what they're looking to do, and the prosecutor and the attorney will go back and forth. The prosecutor will tell your attorney, and it's very foolish not to have one, what the problems are, why they want to discipline you, and the actual nature of the discipline. Your attorney will go back to you, update you as far as what's going on, and then you could go from there. You could settle the case at that stage, and often it's advantageous to do that, even though it's going to result in discipline, because that's generally when you get the best, quote, deal. That's generally when you get the best deal. So if it's acceptable to you, the practitioner, that's the time to try to get a what's called a consent order, which will spell out the terms of the deal. Then the state has to approve the deal, even after you've said it's okay. 95% of the time they sign off on the deal. If the prosecutor said it's okay, the prosecutor's boss generally will go along for the ride, and you're done. However, the consent order is published. It's on the OPMC website, and it involves some sort of discipline. Censure and reprimand may include a practice monitor, where a certain amount of charts are being monitored every month, or it may include some kind of limitations, such as you can't treat no-fault patients anymore, or you can't prescribe certain opioids anymore, or painkillers, or benzos anymore. Sometimes your attorney could get creative as far as carve-outs that you can't do, such that it allows you enough so you could still make a living as a physician. If it's worded appropriately, very often your attorney can help fight to keep you in the various insurance panels, because what's going to happen is when you're disciplined, be prepared to get a lot of letters from insurance panels that you're being dropped. It's within the contracts that you signed with most of these panels, if not all of them, to begin with. So you want to keep your eyes on that. There are other times where the doctor says, what they're going for, I just can't live with. What they're accusing me of is just not accurate. And you as an attorney make the assessment that you have a pretty good shot to fight this. So you would go to what's called a hearing. Now, make no mistake about it. A hearing is not a level playing field. And what do I mean by a level playing field? Well, in a real court of law, there's a judge, there's a jury. The jury is not paid by the same people that pay the judge, or that pay the state, or that pays the plaintiff's attorney or the state prosecutor. In the OPMC, the state prosecutor is getting paid by Governor Cuomo, and so are the people that work for the Office of Professional Medical Conduct. The investigator, the prosecutor, the people that are on the panel. They're all involved with the state of New York, the government of New York. Very often their offices are right down the hall from each other. So you're not getting a level playing field per se. And the whole system is not the same as the system in a court of law. Like I alluded to before, there are no rules of evidence. So that the administrative law judge, who's not a real judge, but does serve the function of a judge in these hearings, he or she works for the state, just like the prosecutor does. And very often, but not always, they know each other. So this is something, and they know each other well. So this is something you have to keep in mind. I'm not saying that these things are fixed. That's not what I'm saying. What I am saying is it's not a level playing field. Who is the jury here? The jury are two physicians and one layperson. In matters of medicine, the layperson generally will go with the two physicians that are involved, that are on the panel, that help decide your fate. But the physicians have a relationship with the Department of Health. So again, these are not outside, totally objective people, as much as they try to be. And they try to be. Let's give them the benefit of the doubt. So these are all factors that you and your attorney have to factor in before you decide whether to go ahead with the hearing. Also, a hearing, unlike a real court of law, it's very limited discovery as far as what you could get. Usually you cannot depose, have any pre-hearing depositions. You're just very limited as far as what you could obtain. You'll get the state's evidence that they're going to use prior to the hearing. And several years ago, they changed the law. If there's any exculpatory evidence that the state has, they have to make it available to you. And you're relying on the state's honesty to make that exculpatory evidence available to you. Exculpatory evidence, for those of you that don't know, that's evidence that helps you, the doctor, as opposed to the prosecutor. All right. It's hard, but not impossible, to win a hearing. And again, preparation is the ball game. Getting the appropriate witnesses, preparing the witnesses. PRI, the insurance company that's co-sponsoring this event today, they have coverage of up to $25,000 of legal fees for these matters. Often, the $25,000 is not sufficient to take you through the end of a hearing. The legal fees involved in these matters can often go above $25,000. So that's a factor for a lot of people that are involved in these kind of hearings also. All right. All right. Let's get back to the penalties. Often penalties will involve taking various courses. They'll involve sometimes fines of not more than $10,000 for each finding of guilt or of each allegation that you agree to in a consent order. So if there were, usually 1 day's treatment involves 1 point of guilt. So 1 day's treatment generally would only be $10,000. But if they're looking into 5, 6, 7 patients, you could be talking about a lot of money. A lot of money. All right. In extreme cases, and I've actually had some instances where they ascertain that a physician is an immediate menace to the public health, such as the physician came in to the operating room high on opioids. There was an immediate suspension. They suspend and ask questions later. Now, there will be a hearing afterwards, within a certain amount of time afterwards, that there will be due process. But in order to protect the public, the state has a right to summarily suspend. That means immediately, without any due process, the physician's license to practice medicine, because that physician is determined to pose an imminent danger to public health. Another example would be a patient, a physician that, let's say, was senile and was just writing prescriptions that had nothing at all to do with the patient's condition and was an imminent danger. The patient's not getting treated appropriately. That would be another instance of where summary action would probably be appropriate. Now, there are problems as far as hospitals that become a large part of the Office of Professional Medical Conduct complaints over the years. It often involves physicians that just don't like the new way hospitals are run. As we all know, many of the hospital systems, due to mergers and takeovers, are now being run by different entities. And I'm not here to say whether various large hospital entities, whether it's New York Presbyterian, Northwell, you name the system, Westchester Medical, you name the system. Upstate, you have many fine systems. But sometimes the paradigm as far as how they are run changes. And physicians don't like the change. And I'll give you an example. It was an example upstate, won't name the city, where the new owners of the hospital were making a big marketing ploy out of robotic surgery. The surgeon, my client, was a traditionalist as far as in the way that he performed his surgery, and he just wasn't going to go along at all with the move into robotics. He was very vocal about this, and He expressed his difference of opinion once, twice, in the appropriate forums, professionally, but he didn't give up. And he started getting louder and louder, and he started expressing his opinions in inappropriate forums. By that I mean the halls of the hospital and at points of meetings where it wasn't appropriate to express his opinion. And he was taking his differences public in ways that it was becoming public to various outside media, like Facebook and other goodies, LinkedIn. And it got to the point where the hospital said enough. And what did they do? They started looking into this physician's treatment of various patients. And they took, in this particular case, 100 different records, and they looked and delved into his records, and they started finding things. And one thing led to another, and lo and behold, he was fighting for his hospital privileges. It affected his privileges for more than 30 days. There was a report to the Office of Professional Medical Conduct. This was a general surgeon who would take a lot of high-risk surgery. So frankly, a lot of the procedures he performed, you could ask all sorts of questions about. And we could argue much longer than what's left in this seminar, whether his actions were appropriate, were the incisions appropriate, et cetera, et cetera. But this gentleman was fighting for his professional life. He won in the end. But the lesson that he took from this in the end was you have to play well in the sandbox with others, especially in hospitals and in medical groups in general. If you're constantly being disruptive, you've heard the term a disruptive physician, the hospitals have the means and the will to make life a living hell for you. So if the hospital is not an environment, if it becomes a toxic environment for you, you want to move on to another place to practice. Or if a group of medicine becomes toxic, you can't practice the way you want in that group, you move on. You move on to another group. Because what's going to happen is they will eventually find a reason to report you and to tie you up in knots, and you'll be trying to defend your professional life. It's not a very pleasant situation, I could assure you. Not a pleasant situation at all. Now, as far as resigning your privileges, or resigning from a medical group, if you resign while you are under investigation, like try to get out of it, that's reportable. That's reportable both to the National Practitioner Data Bank and the Office of Professional Medical Conduct. As a matter of fact, the National Practitioner Data Bank has recently gone so far as to say that if you were under investigation when you resigned and you didn't know that you were under investigation, that's still reportable. It's unbelievable, but that's what they said. Now, please do not confuse resignation with that you didn't renew your privileges. If your privileges have ended and you leave, that's not resigning while under investigation. You just didn't renew your privileges. That's different. All right? And again, consult your legal counsel before you do this. It's easier to ask before than to deal with the consequences after. Also, I would recommend that at least once a year, all of you do what's called a self-query, Query. It's $4 on the National Practitioner Data Bank, because you will see anything that has been reported to your file. So there was a report made a mistake, another physician from another state where you are also licensed and you may have forgotten about. There was a problem there, and you want to get that off. If there was an error, and there's a way to do that, you most likely you'll need help from an attorney to do that. So, for example, let's say during your residency, you had a residency in Florida, and you had a license in Florida. Something happened in Florida. You may not even been aware of it, that somehow affected your inactive license. You have a duty to report that to the New York Department of Health in New York, and actually the New York State Education Department that holds sway over your license. That's the New York State Physician's Profile. You have to report that. If there's a change in the hospitals that you're on staff on, you have to update your physician's profile, even if it's not a time that you're re-registering. You have to do that within 30 days of something like that happening. Important to know. All right. Now, it's important to know your rights when someone's investigating you. The state can't just do anything against you. I mean, we've had instances where during an interview, one of the interviewers, and I couldn't believe it, started asking questions about this particular physician's Yelp reviews. That should not be allowed. People with Yelp, you don't even know if that's their real name, if they left the name at all. You don't know if they were ever your patient. You don't know if they're just trying to get back at you for whatever the reason. The bill was too high, you kept them waiting too long, or they just don't like the way you combed your hair that day. Or they were just pranking you for whatever the reason. They were jealous of you. So, I mean, you have a right not to answer a question like that. Or if they start asking you about prior relationships, you have a right not to answer a question like that. But you also have to be prepared for questions that might be okay to ask like that. And I'll give you an example of a real situation that did occur. We had a client who had a very nasty divorce and involved a restraint order. And the state investigator, thinking that she had a gotcha moment against my male client, said, "So, doctor, could you tell me about that restraint order that says you can't go anywhere near your ex-wife?" And he was able to state, because we knew, and he had disclosed it to me what was going on, and we actually produced the order, that the investigator had gotten it backwards. That indeed, my client had gotten the rights to raise his child, that his wife had no visitation rights, and indeed, she had a restraint order against both her child and my client, that she couldn't come anywhere near them. And it was for the fact that she was physically beating up my client. So you have to be prepared for some pretty dicey questions. Although the letter that you get from the state will often or usually spell out which patients are involved, and sometimes will dig down into the weeds which issues are involved, they do have a disclaimer in that list generally saying, we can ask you other questions too. And within reason, that's a legitimate question. In other words, if there was a consent order against you, remember we talked about you have to have the morals, you have to have good morality, good morals. Well, having a consent order against you, you may not have good morals if that were the case, if they found out that you were you had that restraint order, I should say, the restraint order against you. If you were beating on your wife, or your wife was beating on you, and your wife was the physician, that would come into play. We've once had a case where a physician was obsessed with another person, and it was a patient, as it turned out, and she would not let go of this patient as far as harassing this patient, and there was a criminal misdemeanor conviction of her. Now, when you are convicted of a crime, misdemeanor or felony, what occurs is that crime is reported, and it becomes what's called a referral hearing, which means that it's just over the punishment of the crime. You can't say I really didn't do it. You can't say I didn't harass that patient. That's a done deal. You were found by a court of law, or you pled to the charges that you did what you did. You harassed this patient. That's grounds for discipline. And by the mere fact that you were convicted or pled to a crime, and you could give mitigating factors. Maybe there were mental health issues at the time that you've dealt with since, and that's another thing. When your attorney determines that you're deficient in some area of your practice, you'd be smart to take immediate action to try to shore up that deficiency. It shows the state, even before you get to the interview, that you've taken this seriously and you're trying to improve yourself which is what the state wants to see, and it's also good medicine. So that if your charts are deficient, it's probably a good idea to take a legitimate course in charting. If you have a substance abuse problem, it's a very good idea to join the CPH program in New York State. Get help as soon as possible. Same thing as if the problem has to do with infectious control, you want to take various courses in that. If it's determined that you were a disruptive physician, you want to take courses to try to ameliorate that as far as being a disruptive physician. They have courses in all of these things. And the more proactive you are, the better. If there was a HIPAA violation, you want to take courses in HIPAA. OSHA violation, take courses in OSHA. Very often they're online, but make sure they're legitimate because the state will see through the phony baloney shortcuts like a $3 bill. Do not try to fool the state. That's another thing that's very important. Whether you're at a written submission, an interview, or a hearing, your credibility meaning you, the witness, the physician in trouble, and your attorney. If you have credibility, you have a very good shot at emerging from this unscathed. The first time that they discover you are lying or hedging or not telling the truth in some way, you are toast because they will not believe anything else you say, especially in this forum. If you actually go online, and you can, in the DOH website, and read the actual reasoned decisions of the hearings, the one word you will see coming up more than any other is credibility. And when they find against the doctor, find, F-I-N-D, against the doctor, whatever the discipline actually meted out is, you will see the word lack of credibility. His witnesses lack credibility. The doctor lacked credibility when he or she said this, that, or the other thing. The lawyer lacked credibility when he asserted the exhibit that they showed lacked credibility because perhaps it wasn't signed, it wasn't dated, that kind of thing. Credibility is the most important thing that you and your attorney can do to prepare for your interviews and your written submissions long before any hearing. Because if at an interview you come off as believable, as knowledgeable, you stand a much better chance of ruling the roost, of winning. I recently had a physician. The problem he was there was almost irrelevant. But for 45 minutes during his interview, he came across, because he was, as sincere, as genuinely interested and concerned about his patients, about a doctor willing to go the extra mile for his patients. This came across, and instead of winding up with severe disciplinary action against him, and it very easily could have gone that way, he wound up with what's called a letter warning, which basically in the future, do this a little bit better. Be a little more careful with that, and life goes on. I mean, I have to tell you, I was pleasantly surprised, but the key here was his sincerity, his honesty, his knowledgeability came through during the interview session. And the doctor who interviewed him, the investigator, the non-physician who interviewed him, they wanted to try to find something in his favor. And they were evidently able to because he came out unscathed. Well, at this stage, I see that the clock is just about showing that this today's seminar is done. And I want to say that we're about to conclude today's seminar, but if you have any questions that weren't answered, or if you would like someone from our team to contact you, please reach out using the contact methods you see on the screen right now. We hope you've enjoyed today's webinar, and on behalf of all of us here at Frier Levitt and at PRI, we want to thank you again for joining us. Have a great day, and see you next time. Bye-bye.